Hello and welcome to today's edition of Legally Yours. I'm Carolyn Griffin and I'll be your host. And today we're going to address topics regarding depositions, what they are, why you do them, and how do you prepare for them. Our expert today is attorney John Buten. Welcome, John.
Carol, nice to be back.
Yes, wonderful to have you again.
Thanks.
So let me start out by asking you, what exactly is a deposition?
Okay. A deposition is a sworn statement, and a deposition is given when you're involved in litigation, meaning that if you, in a typical personal injury, medical malpractice case, or any civil action, if a lawsuit is filed, the parties engage in what we call discovery. Discovery is, first it's written, the other sides, and then send you written questions. We send them written questions, they answer them. Once you're done with the written part of discovery, you set up what we call depositions, which are statements given by the parties, witnesses, physicians, things like that. So you don't do a deposition unless you're actually in litigation.
Okay, and that was going to be my next question. When do you do them? So you're in litigation and someone has to request you to do a deposition?
Right. Usually the other side's lawyers will send out a notice of deposition of, for example, in a car-truck accident, the plaintiff, who's what I represent, the person injured, gives their deposition first. And then after the plaintiff's deposition, you want to take the defendant's depositions, you want to take like in a truck accident case, you'd take the depositions of the safety manager, perhaps a guy who set up the trip, things of that nature.
Okay. And why would you actually, what I want to ask you is, do you do them in a workman's comp case? Would you do them?
In Illinois, you do not do depositions in a workers' compensation case of the people involved. So. In a workers' compensation case, again, I'd represent the petitioner, the one who got injured, and the other side, you bring in the claim against the employer. Depositions are never done of the injured worker or anybody at the employer. Sometimes, though, you'll do a deposition of a doctor, the surgeon who, operated on the guy's brain, his leg, whatever it might be. You would do them then. But even that's pretty rare. Mostly in workers' compensation cases, it's just exchange of documents and you go to a trial. But in a civil case, where there is actual litigation, a lawsuit's been filed, depositions always occur.
Mm. And are there any rules that you need to follow when you're doing a deposition?
Sure. Whether it's a car crash case, a premises liability case, medical malpractice, or a construction accident case, yes, the same rules are going to generally apply to all cases. And the first rule, believe it or not, is just tell the truth. Mm-hmm. I tell people, I don't know, over the last 25, 30 years, I've probably done 5,000 to 7,000 depositions. You just want to tell the truth. That way you don't have to worry about anything later on. Now, you tell the truth to the best of your ability and what you remember. But that's the most important thing. A second rule would be, do not volunteer any information, all right? And if the lawyers are the ones who ask the questions, and the lawyers, if they're even decent, should know the answer to any question they ask before they ask it. You're going to know what the records show and what the photographs show, and you should know the answer before you ask the question. So, you just want to answer the question that is asked of you and be quiet. Where were you coming from? I was coming from home. You don't need to tell them, well, I came from home, stop. You answer it and you be quiet. You make the lawyer for the other side who's asking the questions, make him or her earn their money. So don't volunteer, be honest. And then third, before you answer a question, make sure you hear the question. And second, that you understand the question. You never want to answer a question that you don't understand. Mm. So if you don't understand it, you just say, I don't understand the question. What do you mean? What are you asking about? And they'll rephrase it so perhaps you can answer it. But you don't have to answer every question. If you don't know an answer, you say, I don't know. I don't recall right now.
Okay.
Okay? You can always recall later, and that happens a lot of the times. They'll They'll ask you how have your injuries affected you, and you know, from the time you get up to the time you go to bed at night, and then maybe you have problems sleeping due to pain. You answer it, and you're going to recall something after you're done. That happens almost in every deposition. So you can always add to it later, just by telling your lawyer, oh, I remembered this. After the next day I thought about this, and then just tell your lawyer, and he'll tell the other side about it, and it's usually not a problem. So if you don't recall everything, don't worry about it.
So I'm just curious, you said the main number one rule is to tell the truth. Are there times when people, you think they maybe know that they're not answering a question truthfully, or do they do it unwittingly, unknowingly?
That's a good question.
In your experience, I'm just asking.
I think people generally know if they're telling the truth. And it's really important because, down the road, if you wind up in front of a jury, or a trial, you have to know what you said in your deposition. And if you're lying in your deposition, chances are good you're not going to remember what you said because you lied.
That's true.
So just tell the truth and be done with it. That way you never have to remember what you said, because the truth is never going to change. It shouldn't. Well, maybe nowadays. but in a deposition, it should not change. So that's the most important rule, is just to tell the truth. And don't worry if you don't recall everything or if you don't remember anything. It's okay.
And it sounds like, definitely, based upon the information that you just shared with us, less is definitely more.
Yes. When they're asking you about, how the accident happened, things like that, yeah. You can answer ideally, you can answer any question with 5 to 6 words or less. I've only had 2, maybe 3 clients in 30 years that have been able to do that. But generally, yeah, less is best.
So tell the truth, do not volunteer information, and then I wanted to ask you about if a person, regarding them hearing and understanding the question. Can you expound a bit more on that?
Sure. Lawyers have a tendency, and we're good at this, to ask the same question 4 or 5 different ways. So if you've heard the question the first time, and if you've understood the question, you should call the lawyer out and say, hey, Miss Lawyer, I think I already answered that question when you asked me where I was coming from before the crash. Because that question can also be asked, well, before the crash, what were you doing? Well, it's the same thing.
Yes.
Just asked in a different way. And I'm guilty of that. I think most lawyers are guilty of that. We can't help ourselves sometimes.
So then my next question would be, how do lawyers prepare for a deposition?
Okay. Well, all we do at my firm is personal injury cases, whether it's car crashes, planes, trains, automobiles. We do a lot of construction accidents, a lot of railroad injuries. And you prepare generally the same way. As a lawyer, you want to know what all the facts are. You know what kinds of questions are going to be coming. And then you have to know the medical records. You have to really focus on that in most of my cases. So it's very important that you're prepared before you bring the client in and prepare them for a deposition, which is very important.
Okay. And so would you prepare the same way for a car crash, say, as you would for premises liability case or a medical malpractice case or construction? You just touched on those, but would the preparation be the same for each of those instances?
The preparation is going to be similar. I tell people usually it's a good idea to go back to the scene of the accident or the premises where you got injured. The construction accident case, usually the job site will have changed. Obviously, if you're building a building, it's going to look different. So it's ideally, you'll get out to the scene of wherever you were injured, and you'll take photographs so you know what the scene looked like on the day that you got hurt. So it's important to be very familiar with the scene, and then also anyone you spoke to. I'm talking about the client. Maybe you spoke to co-workers at the construction site, or you spoke to the truck driver, the policeman at the scene of the car crash. It's important that you know the dates and times that you spoke to different people, Now, for example, in a car crash case, you spoke to the police officer on the day of the crash.
Sure.
But a construction accident case, you might have spoken to people weeks afterwards. Oh yeah, I ran across this guy, went up back to the job site, and he said, yeah, I recall seeing that crane, and I had some concerns about that crane before it fell down. You're going to want to get that person's name, address, phone number, and ask them if they'd be willing to testify for you. And usually you'd be surprised. People generally will want to help, if they can.
Mm-hmm. And so you as an attorney, do you typically follow up with those people based upon the information? So you'll go and have a meeting with them even before it goes to trial?
Oh, you mean with the witness?
Yeah, with the witnesses.
Witnesses, yeah. What we do generally as soon as the case comes into the office, we'll send out witness statements, we'll make phone calls, and get something done in writing. It's important to me to get a witness's statement in writing because, maybe a year from now they'll take the deposition. It's important that you can then send a witness a copy of their earlier written statement, photographs, police report, things of that nature, just to refresh their mind once again as to what they saw and what happened.
Okay. So my next question for you would be, how long does a deposition usually take? How long does it last?
In Illinois, there's a rule now that depositions have to be completed in 3 hours. Now, in federal court, the rule is different. In federal court, a deposition can last days. There is no time limit. Personally, I think if you can't do a deposition in 3 hours, there's something wrong. Both sides should be able to do, let's say you have an accident with a car accident, for example. You ought to be able to do that deposition in an hour or less. If I take the deposition of the person who caused the accident, you should be able to do it in an hour. And I think most lawyers would tell you, I do that. Now, when you're taking the plaintiff's deposition, the insurance company lawyers will usually, if they're really good, they can do it in an hour or two. But they'll often take the full 3 hours. And they'll spend a lot of their time on the medical stuff, the medical records, the surgery and the interaction between the doctor and the patient, my client. So that's where they spend most of their time on, the medical information.
And how do you, as an attorney, how do you prepare for a deposition?
If it's a doctor, as far as a client, I will bring them in. It's important that you spend a fair amount of time with your lawyer before you give a deposition. And after preparing for your deposition with your lawyer, if you're not completely comfortable doing it and going in and doing the deposition, then by all means, don't do it. You can cancel it, reschedule it, and get it done. And that happens occasionally. But it's important, really, really important for the client to be very comfortable going into the deposition so they can ace it. I always tell people, I prepare, but I'm also preparing the client. Mm-hmm. And for example, you want to look nice. You want to dress nice. You don't need to wear a suit and tie, but you don't want to come in tattered jeans and a t-shirt either. You want to dress nice because what happens after the deposition, the lawyers for the insurance company typically will do a report for the insurance company. And in that report, they tell the insurance company their impressions of you. Mm. You've heard the old saying, first impressions mean a lot, right? Yeah. So you want to make a good first impression. You want to answer questions yes or no if you can. You want to be polite. You want to be courteous. And you want to answer the questions honestly. Because if you're not going to be honest about it, your case is going to go nowhere. Mm. So again, the most important thing is just tell the truth. And if you tell the truth, the defense lawyer will write to the insurance company, this person has a lot of credibility. They're honest, they knew the facts, they knew how they got hurt, they knew who was involved, they know what happened to them and why it happened, and they're honest. And they'll put that in a report, which is good for you because you hopefully can settle your case without going to a trial. And I'll tell you the one area that always pops up in almost every case is a person's past medical history.
Oh, okay.
All right? That goes back to the first rule, just tell the truth. I mean, I've read studies that they say maybe 80% of all adults in this country have had low back pain. So, when you get to your deposition, the lawyer is always going to ask you about your past medical history to see if you've ever injured that body part or had problems with that body part in the past. The only time I get concerned about that is when people lie about it. And I tell people, don't, and sometimes they still do. It doesn't make a difference. I don't care if you've had 3 back surgeries in the past. It makes no difference. As long as you tell the lawyer about it during your deposition, you're fine. The only time you get in trouble with your past medical history is when you're not honest about it. So there's nothing wrong with that. There's nothing wrong with having pre-existing conditions, pre-existing injuries. So what? It's not going to hurt you if you're honest about it. But if you're not honest about it, number 1, the case will not settle. Number 2, you're probably going to go to a trial. And number 3, when you're up on the stand testifying in front of a jury who are just, there are 12 people there spending their time away from their family, time away from work to hear your case. And if I'm sitting on a jury and if someone's lying to me about anything concerning their past medical history, I would turn them away because there's no need for it. And I think most jurors do understand that people have pre-existing conditions. So let's say, for example, let's say you had a car crash case and you injured your low back and you have the pain going down the back of your leg. That's called sciatica. If you have the pain going down the back of your leg coming out of your back, you've got a bad, serious injury. And let's say you've had back injuries in the past, and you've also had pain going down your leg in the past, but you haven't had that condition for 2, 3 years, even 6 months. And your doctor discharged you from care and said, Carol, you're fine, the back injury is healed, be on your way. No restrictions, do whatever you want. Carol, you're fine, no limitations, whatever you want to do, you can do it. So you're back to the way you were. Now, you have a car crash and you get asked, have you ever hurt your back before? If you say no, chances are you're going to get another lawyer because I'll withdraw. If you say yes, I've had 3 back surgeries, I've had the pain down my leg in the past, blah, 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 just tell them. And then they'll say, well, how are you feeling the day of the accident? Again, just be honest and say, well, I was fine. I was working. I had no problems outside of work doing whatever I wanted to do. I had no limitations. Okay, that's fine. But now you've told the truth and you don't have to worry about it. And oftentimes you'll have people that do have, my name is Carol, I had this car crash and I had back pain before the accident. I've had back surgeries. And on the day of the accident, yeah, I still did have some low back pain. I would occasionally get that pain shooting down my leg even though I've already had the surgery. But after the accident, it all got worse.
Okay. Yeah.
Okay, the back pain became almost debilitating. Some days I couldn't get out of bed. I couldn't go to work every day. And so it made everything worse. The law in Illinois, anyway, does not punish you for having a pre-existing condition. So even if you did have back pain, I've had clients that were seeing doctors and they got involved in a big accident. And the doctors will say, yeah, Carol was here and she did have this, I was treating her even at the time of the accident and just before the accident, but this is what the accident did. This is the changes that occurred because of this crash. And they have diagnostic tests, MRIs, X-rays that can show the changes that occurred as a result of the collision, for example. You do an MRI and let's say you have a herniated disc at L4 level in your back, and you do have that sciatica every once in a while. You have a car crash, and lo and behold, you now have a new herniated disc at the level below, and the sciatica is so bad that you can't walk sometimes. Okay, what do you have there? You have an aggravation of a pre-existing condition, as well as probably a new injury. And again, I tell people, I really don't care about what your past test results showed. It doesn't matter to me. Doctors treat symptoms. Doctors do not treat test results. So, I always ask people, well, how were you before the accident? Well, I had this problem, that problem. Okay, well, tell them about it today. And then the truck T-boned you. What happened then? Well, everything got worse. And then you describe how it got worse. And the next thing you want to do with those people, you want to get lay witnesses, their neighbors, your pastor, friends, co-workers, ex-spouses, I think, are the best witnesses for different reasons.
Really?
Yeah.
Why so?
Why? Because I've had a lot of ex-spouses will come in and say, yes, I was married to Carol for 25 years, and we got divorced. It was an ugly divorce. I wish she were dead. I can't stand her. She's a piece of whatever, okay? But she was a good mom. And before this accident, she was active with the kids. She took them out. She went to their baseball games. She even helped coach their basketball team. The kids loved her. She loved the kids. So as much as I hate her, she was a good mom. Great. And as a result of the crash, she's no longer the mom she was. That's valuable information. I mean, you've got an ex-spouse. Yes, people say, why is that? Well, it's because I know, generally, the ex-spouse it's good if you can get along after you've been divorced, but a lot of times you don't, or you don't speak much, you just see them. And they can testify, I saw these changes in her.
Okay.
She doesn't do the things with the kids she used to do. She's always grabbing her leg. And so while I can't stand that woman, the changes I've seen from the crash are pretty significant. That's money in the bank. I mean, it is. And same with lay witnesses. You ask your next door neighbor. Before the crash, Carol was out there every summer tending to her garden. I would see her walking the dog. She did all these things. Now, what's her garden like now? It's run over. She doesn't garden anymore. I don't see her walking anymore. And when I do, she's got a limp. Does she know you're watching her? No. I see her walk by. Mm-hmm. Those are the kinds of witnesses you want in your case.
Just for the record, any ex that I would have, they would only say something wonderful about me.
Okay.
Now, do you have to remember dates and times at the conversations?
Yes.
You do.
To get a conversation into evidence before a jury, you have to know the date, time, and place of the conversation. Does that mean you have to know the exact time? No, but you should, or even the exact date. You should be able to nail it down to within a week, and then what the conversation was about. So it is important to know dates, approximate dates, times, and what was said, and then who was present. Now, as far as medical records, see, a lot of defense lawyers will ask, well, Carol, when you saw Dr. Jones they'll try to get you to fill in the date. I tell clients, don't worry about the dates. It's kind of like asking you, Carol, what did you have for dinner 3 weeks ago Wednesday? Unless you have the same meal every Wednesday, you're not going to remember that. Yeah. No one knows, and I don't think a jury would expect you to know what you had for dinner 3 weeks ago Wednesday. So when they ask you, what did you tell the doctor on this date, or when's the next date you saw the doctor, you don't need to know that. You do not need to know that. You just need to know generally what your doctor told you, what you told the doctor. But as far as on June 1st at 9:30 a.m., I was at Dr. Jones's office and I told him blank and he said this back to me. No, you don't need to know that. It's not necessary, and people aren't expected to know that. You should just know generally what you had, kind of conversations you had with your doctors, physical therapists, things like that. The exact date for that, no.
Can you just very quickly and briefly touch on what types of questions are generally asked in the different types of cases, like a car or truck case, premise liability or construction accident, etc.?
For a car crash case, you're going to need to know the scene of the accident, the layout of the roadway, and speed. Time and distance is what's important in a car crash case. Premises liability case, you're going to need to go back to the scene of where that happened. And on premises liability case, I get calls all the time, well, I was at Carol's house and I fell down the stairs and I broke both my legs and I need surgery. I want to sue Carol. Guess what? You probably can't. Because in a premises liability case, the plaintiff has to be able to show, and this is done through preparation with your lawyer, that the premises, that the owner of the premises, in this case Carol, either knew that her stairs were bad or she should have known they were bad. And if you can't prove that, then now you have to show that you created the dangerous condition at your house causing the injury. So it's different, and you prepare people for those depositions different than you would in a car crash case. Medical malpractice cases, it's important what was said to the doctors, not necessarily the exact date, but the conversations between the doctors as far as what kind of treatment was recommended, what the doctors said, what you were told about the risk of any particular procedure, and things of that nature. A construction accident case and railroad cases that we do, you need, again, to know you've got to be familiar with the scene, and you usually are. And again, what other people said.
And then lastly, if a defense lawyer asks for witnesses' names, addresses, and phone numbers, do you have to tell them this? Do you have to divulge that information?
Yes, you should want to. Before you get to your deposition, you should be able to speak, you should speak to your friends, co-workers, a boss, your pastor, as to whether they'd be willing to talk about how the injuries affected you. Get that information up front, get it before you get to your deposition, get it to your lawyer early and often, so the lawyer can disclose that information before the deposition, and then you might want to bring those people in to give depositions as far, just to say is, you know, I've known Carol and this is what I saw, the way she was, and these are the changes. Mm-hmm. But it's important, very important to get those kinds of witnesses lined up well before your deposition, because a defense lawyer can ask you for their names and addresses if you mention them during your deposition. You want that stuff out there beforehand, though, if you can.
And you, as the attorney, would be the one providing that information, not the client.
Right. The client provides it to me.
Okay, okay.
And then I pass it on. But again, those witnesses, the lay witnesses, I think are the most important witnesses in any trial. More important than your doctor, your physical therapist, or any expert even. Why? Because usually a neighbor, a co-worker, and a friend, while they like you and they want to help you, they really don't care one way or the other whether you win the case. They're just there, and most people don't like coming in and giving a deposition. So they're just going to tell the truth 99% of the time, and whatever happens, happens. So I like those kinds of witnesses.
Sure. Well, Attorney Booten, thank you, Buten. Thank you. Thank you very much for joining us tonight for this edition of Legally Yours. And thank you, viewing audience. I'm Carolyn Griffin. Have a great day.